In 2005, I published Rights to Recognitions, Minority Indigenous Politics in the Emerging Taiwanese Nationalism in Social Analysis, and which details the indigenous rights movements from the early 80s to the late 90s, shifting from individual rights to the collective rights. In the same year, the Indigenous Peoples Basic Law was passed, and a series of reforms followed. The language revival, we've been talking about a lot of practices they implement to increase the public use of indigenous languages. And the indigenous education area, even though we said that there were a lot of schools established, but there are a lot of problems facing the system as well. Traditional territories, the debates surrounding the public versus private land, and what categories of land can be used in this act.
The first part is talk about the indigenous peoples in the ROC law. I think it is common for us to understand that indigenous people across the globe, we all shared similar colonial experience. So if we want to understand the indigenous legal position or the rights situation in Taiwan, we must look back to the history. The awkward question remains is what to do when the basic law contradicts other legislation was left unanswered. Even the Article 34 stipulated that all relevant laws and regulations should be amended or repealed within 3 years from promulgation of the law. But the question remains unanswered because a lot of court decisions, even the government actions, still says nothing about the basic law.
I use the table 3 to introduce what is common real indigenous cases, include theft of forest products or forest byproducts, hunting or killing protected wildlife species, possess self-made hunting gun. Indigenous division usually deal with not real indigenous cases, just very strange. The reason of low number of real indigenous cases is one, standard of assignment of indigenous cases are determined by whether the defendant is an indigenous person has been registered, not by the issue. 2, small proportion of real indigenous cases in the division. 3, subordinate ranking of assignment.
In January of 2013, the judicial branch set up the ad hoc chamber of indigenous courts in 9 districts in Taiwan, emphasizing that these specialized units would ensure respect or 尊重 for indigenous people's cultural differences and help secure their judicial rights of the 司法权益. The jurisdiction of the indigenous court units extends to all criminal cases involving an indigenous defendant, to civil cases within a particular prescribed set of categories, and then to other cases involving an indigenous litigant as approved by the judge. So the court's jurisdiction is therefore primarily grounded on the identity of indigenous people, as Judge Tsai mentioned, rather than case type involving matters specifically relating to indigenous peoples and cultures and lands. In conclusion, the paper that this little talk I've given here has explored the practices of local judges and the strategies they've developed to fulfill the judicial branch's aim for the Taiwan's new indigenous court units. In daily practice, these specialized courts tended to operate as ordinary court institutions.
专案辅助的内容跟法服辅助的内容是相同的，也就是除了律师代理之外，也包含着法律文件的制作，还有法律咨询，不只是当下的一问一答的方式进行，它也包含着比较复杂的法律议题，会有专门的律师带回去研究，拟成一个正式的咨询结果之后，再将研究的结果交给申请人。因为原住民专案的关系，我们法服可以接触到更多的原住民，也提供了这个原住民更多的法律辅助。那这个部分，除了符合原基法第30条这个司法保障的精神之外，这个法律上的禁用权，我觉得多少也带一点转型正义的一个理念。90%以上的法律都是没有在原住民的任何代表下就订定完成的。那这些制度是对原住民来讲是陌生且不公平的，所以这个法律辅助是专案的部分，或者是强制辩护制度的部分，其实都是转型正义的当中重要的一环。
Since the 1980s, Taiwan's indigenous people have faced many problems when they go hunting. First, they can only use muzzle loader. Second, the Wildlife Conservation Act only allows indigenous people to go hunting for the purpose of traditional culture or ceremony. Third, the regulation asks indigenous people to apply for hunting 20 days beforehand, and they must fill out a form where they need to claim what type of animals and how many they want to capture. From Taiwan's case, we learned there are still ways to implement indigenous people's human rights. First, disseminate international human rights norms fully. Second, we need to educate the public about indigenous culture. Last but not least, we should realize indigenous human rights through judicial agency.
Since 2008, I've been accompanying the criminalization of indigenous people in the prisons of Boa Vista, Roraima. I have a map now, I hope you can see that. It localizes Roraima and Boa Vista, the capital of Roraima, in the far north of the Brazilian Amazon, near the frontier with Guyana and Venezuela. In 2018, the first indigenous lawyer, Joanie Wapixana, from this region, was elected the first indigenous woman to be a federal deputy in Brazil. She headed the juridical department of the Indigenous Council of Roraima for 22 years. And after being elected deputy, has led the Joint Parliamentary Front in defense of the rights of indigenous peoples, being a key figure in the affirmation of indigenous rights. It's, as you can see, it's not by coincidence that she came from this part of Brazil where the indigenous movement is very strong.
Okay, so my talk is entitled A Comparison of U.S. Tribal Courts and Canadian First Nation Courts. One of my books is called Oral History on Trial, and in that book I talked about the use of oral history evidence in Canadian courts and how it could be used after the Supreme Court had said it would have the equal footing with written history. And another was on invisible indigenous, non-recognized communities. In conclusion, my point here is more needs to be done by tribes and intertribal groups to explore their own traditions and regain control of their own community in concert with neighboring jurisdictions. And I think the Washington Coast Salish tribal courts show this can be done in common law practice concepts and indigenous approaches. And I just want to end with the note that they're not all incompatible. There are some overlaps in indigenous practices of justice and law and common law. And one of them is the experts, elders or community knowledge holders, and the indigenous kinds of experts in the common law. The idea of
these measures for making decisions and resolving disputes are in many different sources and are practiced through many different institutions in a variety of ways. And so if we think about law in that way, you can see how it would be easier to talk about the resurgence of indigenous law, the revitalization of indigenous law, legal education, dealing with indigenous people's legal traditions, of course, talking about these things in law schools. And it's energizing to the law students as they question what's going on and express caution because, you know, this is happening in the face of 400 years of colonialism, and there's still lots of challenges that indigenous peoples face, and there's lots of just good faith things that need to be worked out. These students are also instrumental, meaning they want jobs in the field, and you get all sorts of different things that people do when they graduate to work at the interface of indigenous law or common law, or to work in government, or to work in indigenous communities, to kind of reframe and make law.
I will divide my presentation into three parts. In the first two of them, I present the institutional normative framework where the discussion on indigenous rights takes place. And in the third part, I try to bring a more practical ethnographic character and describe some aspects of the interaction between these two peoples in the criminal justice system in their regional contexts. And indeed, my presentation finally come to an end. I have tried so far in a very explanatory and admittedly insufficient manner to present in a quasi-schematic structuring of the normative apparatus in criminal matters today in Brazil regards to indigenous peoples. We have also to particularize structure and operation by analytically the ethnic judicial concept surrounding the Machacali indigenous peoples. The sort of rights I have talked about so far, they are not given an internal guarantee.